Anything that we need to take up before we proceed? All right, very well. Let's bring jurors, please. All right, final arguments for the defense. I believe we'll begin with Ms. D.
Thank you, Your Honor. The law never demands death. That's what lies at the core of issue number 4. Even if a jury finds that the aggravating circumstances are not outweighed by the mitigating circumstances, that the aggravating circumstances weigh more, the jury is still called upon to go that extra step and to determine whether or not those aggravating circumstances, when looked at in light of the mitigating circumstances, are sufficiently substantial to call for the imposition of the death penalty. In other words, there is always a role for the mitigating circumstances, and there is always room for the mitigating circumstances to urge mercy in a case. Before going any further, I would like to say again that these are not excuses for the murder of Melissa Huggins-Jones. Travion Smith is guilty of first-degree murder. Travion Smith is responsible for first-degree murder. Travion Smith will be sentenced for first-degree murder. Travion Smith is going to die in prison. He will never leave prison on his own volition. The only question that is left to decide is whether or not God will determine the time and manner of his death, or whether that determination will be made by the state of North Carolina. In jury selection, we talked about mitigating circumstances. And the instructions that you're about to get are going to have a long definition of mitigating circumstances along with the other legal principles that you'll be called upon to apply to all the evidence you have heard now in both phases of this trial in determining what the appropriate sentence is. And what those instructions say, and forgive me because I have to read them, but what they say is a mitigating circumstance is a fact or group of facts which do not constitute a justification or an excuse for the killing or reduce it to a lesser degree of crime than first-degree murder, but which may be considered as extenuating or reducing the moral culpability of the killing or make it less deserving of extreme punishment than other first-degree murders. Our law identifies several mitigating circumstances, including the young age of the defendant, which you'll be instructed about. However, in considering issue 2, this is going back to the language of the instruction, It would be your duty to consider as a mitigating circumstance any aspect of the defendant's character or record and any of the circumstances of this murder that the defendant contends is a basis for a sentence less than death, and any other mitigating circumstances arising from the evidence that you deem to have mitigating value. Again, the law requires that capital punishment be reserved for the narrow category of defendants who commit the most serious crimes and whose extreme culpability make them most deserving of execution. Travion Smith is simply not one of those defendants. He was 20 years old at the time of the murder, but you've heard considerable evidence about his immaturity. The teachers and the counselors who he worked with through the years universally described him as immature and young for his age. And the state's rebuttal evidence, they've made a lot of comments about how you haven't heard anything about Travion Smith since 2009, but you did hear about Travion Smith since 2009 throughout the state's 4 witnesses in rebuttal to the sentencing evidence in this case. And those records and that evidence underscore his immaturity. Deciding that you think it's unfair for the whole pod to go on lockdown because the person who turned off the TV won't fess up, and you therefore refuse to go to your cell, and after you get pepper sprayed, keep insisting that you were just trying to have a peaceful protest. A peaceful protest in the jail over the TV, that is childish. That is childish behavior. And similarly, acting smart with the same sergeant who pepper sprayed you in the incident over the TV, saying, "Bye, bae." Well, that's childish. Childish behavior that invites negative consequences is the definition of immaturity. So yes, he is old enough to get the death penalty. But are you convinced beyond a reasonable doubt that he is mature enough to understand the nature and consequences of his actions in a way that an adult would? Are you convinced beyond a reasonable doubt that he is capable, as an adult would be, of controlling the impulsive behavior that you heard about throughout the witnesses that you heard in this phase of the trial? Ms. Chiquita said a number of things about perhaps most of the 8th graders have a clinical diagnosis that includes ADHD. I submit to you that as she asked you to do, consider your common sense and your life experience in determining whether or not you think most of the 8th graders have that clinical diagnosis, and whether or not most of the 8th graders have their first inpatient hospitalization when they were 6. I'd like you to, as she asked you to do, use your common sense about thinking back about how many of the parents you knew would put alcohol in their children's bottles to get them to sleep. And just while I'm on this, throughout this whole process, what's critical is that you remember the evidence the best that you can and not rely on what any of the lawyers say. So for instance, if you remember Dr. Evidence also testifying about Zyprexa, which is an antipsychotic, that he was diagnosed through those years, then that's your correct memory. And you should remember the best you can what all of these witnesses had to say. So for instance, if you remember the probation officer, Mr. Shellhorn, also describing Travion Smith as gullible, then you can remember that. And you don't have to rely on just the people who saw him during the school setting and in the programs that he went to before 2009. Part of the answer to why Travion was and is as immature as he is comes through looking at his early life. He was born into an undoubtedly terrible situation. His mother didn't want him. His brother Corey testified about knowing always that she didn't want any of her 4 boys. And she would go years between visits with her sons, and she did not provide basic care for Travion as a baby. Basic care is feeding your child, having food in the home, having formula in the home, changing diapers, putting up basic safety gates in the house, not heating the home with an open oven when you have a toddler and a baby milling about that space in the common area. So Antoinette Smith didn't provide that basic care when he was a baby, and neither did Michael Clark. Remember, Michael Clark was in prison. So who did provide that care? Well, Laura Cannon, in part, and maybe some other neighbors. We know that Laura Cannon loved him. Everyone says she loved him. There are studio pictures of him when he's the age he would have been with her, suggesting she cared enough about him to order the pictures. There's a picture when he was slightly older, but Miss Janes didn't recognize it because she didn't know him then. Said that she didn't know who that was and she couldn't identify that photo. But we know that those two are evidence of the fact that Laura Cannon did love him and did care. So Antoinette Smith gave her baby to her neighbor. And Wake County DSS let that placement stand, never making any inquiry into how she came to be identified in the record as Michael Clark's sister when she had initially been identified as Antoinette's neighbor. And similarly not making any inquiry into the allegation, the comment that Claudia White made in her last CPS report about the fact that she was also concerned about Laura Cannon tearing up Pico's butt when his mother was not there to protect him. And Claudia Janes, this is a long time ago, and maybe she doesn't remember that. What she remembers is that Laura Cannon cared about these children. But we know that she made that report at the time because it's in the record. That's not a back door. That's just a fact that sometimes a record at the time of something is a better document as to what happened at someone's memory 20 years later, or what all their concerns were 20 years ago. But DSS never made any inquiry into that part of the complaint that related back to Laura Cannon, the type of discipline that Laura Cannon was giving to Pico. And again, let's think about how young he was. So the time where Claudia White and Laura Cannon are both still living on Hare Snipe Court was the year and a half. Travion was at most a year and a half old at the end of that time. That is a young child to be having your butt torn up. DSS never did a kinship placement assessment of Laura Cannon's home. And we know there was other domestic violence in that home because she died as a result of the domestic violence in her home committed on her by her husband. But regardless of what the actual circumstances were in that home, we know that by the time Travion was 5, those circumstances were no longer critical in his life because she had been murdered by that time. This is all happening to Travion as he is starting kindergarten and already exhibiting such extreme emotional and behavioral problems that he always had to be taught in a self-contained special education classroom. So by 5, we know for sure he's with Dad, although it's a little bit unclear exactly who he's with from September, I want to say, 1994, when we know both of the children are out of Antoinette's custody, and the time where Miss Cannon has been murdered, so we know he's with his dad. It's a little bit unclear who he's with during that time. But by 6, according to Anne Marie Evans, he's having his first inpatient psychiatric hospitalization. Again, that's not the kind of problems paying attention that might impact a larger percentage of children. There's no doubt that parenting Travion was challenging. But there's also no doubt that he responded well to the structured environments that you heard about in the testimony throughout the second phase of this trial. And sadly, those placements and services were sometimes short-lived for a variety of reasons, because the agencies changed, or because there was turnover in employment, or because somebody was unhappy with the services. But one person who wasn't making any of those decisions at that time was Travion Smith. And he did do well in a lot of those programs, and he didn't necessarily stay in the places where he was doing well. In Ms. Chiquita's PowerPoint, she had a reference to Ms. Myers, and to the fact that Ms. Myers said that the structure at home is never exactly like the classroom. No, certainly not. Certainly not exactly like a contained special ed classroom with like 5 kids in it. No. There's not a structured environment like that at home. But there are ways that those programs are set up to attempt to have dialogue with the parents, and an attempt to help to work with the parents to have some sort of continuity between the school day and home and have some sort of structure. And I hope you'll remember Ms. Meyer saying that as part of that system, she had paperwork that went home every day for the parents to complete and to give feedback, so that she could then have a loop with the kids and be able to talk to them about their progress at home and what was going on with them, and there wouldn't be a total disconnect between those two parts of the day. And because she never got any paperwork back on Travion, she had to have another teacher in the school make up fake home reports so that she would have something to talk to Travion about, to try and give him that encouragement about working on his goals throughout the day. Jennifer Myers also told you that when she told Michael Clark how well Travion was doing, because he did so much better from the middle of that year forward, only half a year, but he did a lot better. He passed his IEPs, he was really doing well in class, and so she wanted to engage Michael Clark around that and talk about how well Travion was doing. And what she told you is that she has this strong memory of telling Michael Clark that day that he was there with the younger brothers, and his response is that she was wrong. Travion was not doing well. Travion was doing poorly. And that's the message Travion heard in front of his younger brothers and in front of whatever other students or peers were there to hear that. I'm not going to talk about all the mitigation witnesses. I trust that you heard them, and I trust that you heard the value of what they were saying. There's no real dispute about the mitigating circumstances that will be submitted to you. You each have to determine individually the weight and magnitude of each of those circumstances, but their truth is largely unchallenged. Travion was born into a terrible situation. He spent several years in an unknown situation with Laura Cannon Champion, and then with considerable emotional and behavioral problems, he went to live with Michael Clark. Travion is not similarly placed to any of his siblings. All of his other siblings were raised after their whatever period of time with Antoinette by either a parent or a grandparent who wanted to have them and who was committed to nurturing and taking care of them. Travion was bounced around until he came to live with his father. His father, who's so upset when he found out that Antoinette was pregnant, that he beat her and punched her in the stomach in an effort to end the pregnancy. That is who Travion ended up being raised by. In our world, in our country, and in our justice system, we put a premium on people taking responsibility for their actions. I want to talk to you about the lessons that Travion was taught about taking responsibility. It is uncontroverted that after Laura Cannon Champion was murdered, Travion had one primary caregiver, his father. And that is who he called the morning after this murder. As the prosecution has already reminded you, Travion told the detectives that when he was interviewed. The morning after this happened, he was on the phone asking his father for advice. Because it's true. Although this relationship might have at times been challenging and difficult for both of them, his father was the only person who was ever there for him with any consistency. And that is who he reached out to. And the evidence shows that neither Travion or his father reached out to the police after that phone call. What else do we know about the lessons that Travion learned from his father about taking responsibility for his actions? You heard from Christina Love about her father's reaction to learning that she had decided to testify at this trial. He was angry. He was furious with her, and you heard the words that she remembered from the phone call. And fundamentally, he was angry because he told her, nothing that has to do with me has anything to do with what's going on with Travion. And he resents any suggestion to the contrary. Finally, what did Travion learn from his father about taking responsibility when Travion learned about his son? Earl Dean Bailey testified about the day that Terrace Magruder and Antoinette Smith and Aaron Magruder showed up at her door. And she didn't need a paternity test for her to know that Aaron Magruder was her grandson. And Travion Smith didn't need a paternity test for him to know that the baby was his. But Michael Clark was furious. And you've heard that this was a back and forth with the probation officer. So this was an ongoing dispute between the father and Travion about the baby. That both of them talked to Mr. Shellhorn about that over time. Michael Clark knows something about the anger and resentment that come along with being forced to take responsibility for a child that you don't want and who you may not even be completely sure is yours. Nothing else explains the magnitude of his anger about Travion's child. The state argues that Michael Clark was actually a good father, good and caring father. And Christina Love said otherwise. She said that he was verbally and physically abusive to Travion and would taunt Travion with the fact that Travion had nowhere else to go. And rather than argue about these two opinions or suggest that perhaps the man's daughter has a little more insight into his character than Travion's parole officer, I want to talk about what we absolutely sort of know for sure. I want to talk about the dialogue or the post-release supervision. The passage in the post-release supervision report that both Ms. Shakita and Mr. Brown asked now Mr. Shellhorn to review with them. So this, if you recall, there was a surveillance officer. So this was not Mr. Shellhorn's notes. These are notes that were populated in his computer program by the surveillance officer who came out that night. And it says, defendant not at home. Remember, there was argument about the fact that when they were, not argument, but there was questions when Mr. Shellhorn was testifying about whether or not Travion had gone off and left the child that day. So this is the entry about that. Defendant not at home. Spoke with defendant's father. Stated the defendant had brought home a baby this date, stating that he was keeping it at the house for the weekend. Defendant's father pointed out the defendant is not even sure whether it is son. Well, is it defendant who's not sure, or is it Michael Clark who's not sure? But anyhow, later in the evening, male and then female friend came to house, and defendant went out to talk to them, leaving baby inside. Defendant's father went outside once to tell defendant to come in and look after a baby. No response. Went out a second time. This is what Michael Clark is telling the officer. Went out a second time and told defendant that he was going to call the baby's mother and come to pick him up, which would have prevented Travion from spending the weekend with his child as he wanted to. Defendant became irritated and disrespectful. Defendant's father called the Raleigh police. When the police arrived, they informed the father that since defendant was on house arrest, they could not force defendant to leave. Defendant's father called P.O. Shellhorn. P.O. Shellhorn stated that if defendant needed to be kicked out, then so be it. And that it did not matter if defendant was on EHA or not. Defendant left the property because the Raleigh police came and told him that his father wanted him to leave, and his father has not seen or heard from him since. So Travion hadn't gone off and left the baby. Travion's in the front yard talking to somebody. Travion was on house arrest. So if he wanted to have any contact with his child, it had to be there in his father's home. And he clearly was trying to take on that responsibility and trying to take care of the child and keep him for the weekend. Travion was proud of his child and wanted to be part of his life. Travion wanted to take responsibility for him. And this so infuriated Michael Clark that he called the police department, and Travion was forced to leave with the child. You can judge for yourselves whether or not that response seems to come from a father who is trying to be supportive of his child and handle the situations that his child has in his life at that moment. And you can judge from all the evidence what sort of lessons Travion learned about the importance of taking responsibility for his actions. Ladies and gentlemen, I ask that you hear the truth of the mitigating circumstances that we're asking you to consider today. Your family and your upbringing do matter. Beautiful, articulate, self-possessed Hannah Jones is a testament to how important it is to have a family that puts the well-being of the children before everything else. The circumstances that have been presented to you regarding Travion's background are true. And while they do not change the fact that he is responsible for and will be sentenced for first-degree murder, they do show the justice of mercy in this case. And I ask that you sentence him to a sentence of life in prison without the possibility of parole. Thank you.
Need a few minutes to set up.
5 minutes.
All right, so ladies and gentlemen, I'll ask you to step in the deliberation room. We'll be at ease for about 5 minutes. Please don't discuss the case among yourselves. Leave your notebooks in your chairs while we set up the courtroom for the next argument. All right, outside the presence of the jury, there's one administrative matter that I need to take up with, and that is, it was reported to me that during, I believe, the state's closing argument, that there was either a recording device or a photo or a camera or something that was being pointed in the direction of the jury, and it was reported that it's the young lady on the second row in the black top with the earrings. Yes, ma'am. Could you tell me your name, please? I'm sorry. Yes, ma'am. Do you have a camera or a recording device or anything that you were using during texting? Would you mind allowing one of the bailiffs just to look through your phone, make sure there were no photographs taken? Okay. If you could do... All right.
First off, I was, before he even came in, I was texting my mom, and he came in and sat down, and then that's when he,
Give him the phone.
All right. Ma'am, if you wouldn't mind just allowing the bailiff to inspect your phone for any photographs as well as any recordings that might have been making. And sir, just, you spoke a moment ago. What's your name, sir?
Stephen McNair.
All right. Thank you. All right, we'll just leave that as it is, and we'll be at ease for a few minutes. I'll hear back from the bailiffs about any information that needs to be brought to my attention. All right, outside the presence of the jury, the individual in the gallery was gracious enough to allow the bailiffs to inspect her phone. It took a few moments to have the phone charged so they could inspect it, and they examined the phone, found nothing that would indicate any violation of the rules of this court. So the bailiffs have asked, and I would extend that as a court order, that all electronic devices are to be turned off so that we have no, individual seat in the gallery, so we have no need to delay proceedings further over a situation like this. With that being said, I believe we're ready to proceed. If you'll bring the jurors in, please. Ladies and gentlemen, I apologize for the delay a bit longer than I'd expected. An administrative matter came up that I needed to attend to outside of your presence, so that has been resolved, and we are now, I believe, ready. Mr. Brown is ready to present the final argument in this case.
Do we kill Travion Smith, or do we condemn him to a lifetime of imprisonment? That is the only question that is left to be decided in this case. There is no longer any doubt that Travion will be punished. Your verdict last week assured that. And there is no doubt that he will be punished harshly and severely. Now you must decide what form that harsh and severe punishment will take. We started talking about the possibility of a penalty phase in this trial during jury selection. And all of you expressed different views about life imprisonment, about the possibility of parole and the death penalty. All of you did say that there would be cases out there where you could consider the death penalty. But each and every one of you also said that you could consider life imprisonment without parole, even for somebody who was convicted of first-degree murder, even for somebody who was convicted of premeditated, deliberate murder done with a specific intent to kill. And each of you also said this, that you could consider mitigating circumstances. Circumstances not just about the crime and the defendant's role in the crime, but about his background, about his character, about his record. I want to spend a few moments talking about the law that you're going to be instructed with in the moments and all, because I know we talked about it in jury selections, and Mr. Waller touched on it, and Judge Ridgway is going to spend time doing it but it's a complicated process. And it's a process that has such importance in this case. You're going to be given, we had talked about in jury selection about 4 possible issues. There's actually 5 in this case. And the first has to do with the question of exactly, it goes back a little bit to what was discussed at Guilt Innocence, which is exactly Travion's role in this case. And the first question is going to be, do you unanimously find beyond a reasonable doubt whether Travion himself killed the victim, 2, intended the victim to be killed, 3, intended lethal force to be used, or 4, was a major participant in the underlying felony and showed reckless disregard for human life, reckless indifference to human life. The reason that you're being asked this question is that because of your verdict and because of how the question was asked during Guilt Innocence, we don't know, nobody knows, because it's only between, we were not there in the discussions, we don't know your verdict, what exactly you found about Travion's role in the killing of Melissa Huggins-Jones. You know that all of us argued about that and presented the evidence last week, and we're not going to go spend our time here going over that. You remember the arguments about that and all. If you found it, you know what you found, and that's the verdict. That part of this question is what controls here. But if you did not find that he himself was the one who did the killing, that he himself did not show that premeditation, deliberation, that specific intent to kill, that he did not intend to kill, then I submit to you that that answer should be no. And if you don't find that unanimously, and if you don't find that beyond a reasonable doubt, the process is over, and Travion will be sentenced to life imprisonment without parole. Assuming if and only if you answer 1A, yes, then you move down to issue number 1. And that's about the existence of aggravating circumstances. And again, you are required to find unanimously and beyond a reasonable doubt the existence of an aggravating circumstance before you can find it. Once you decide what aggravating circumstances exist, the next question for you is going to be the existence of mitigating circumstances. This question, issue 2. And I want to spend a few moments talking about that and that issue and about the law about it. And we're going to get back to what we mean about the law. But in doing that, you're going to get a definition of mitigating circumstances. And I know Ms. D talked about it a little bit in her closing, but Judge Ridgway is going to tell you about the definition of mitigating circumstances, and it's things that we talked about in jury selection. It's a group of facts which do not constitute a justification or excuse for a killing or reduce it to a lesser degree of crime than first-degree murder. In other words, the evidence that you heard during this past week is not things that we are saying in any way is an excuse or justification or something that makes it another crime other than first-degree murder. If it was, you would have heard that evidence in the first phase. It is evidence, however, that shows why, when you're choosing between two very harsh and severe punishments, why one is more appropriate than the other. Why life imprisonment without parole is the more appropriate punishment in this case. And in doing it, the type of evidence that you heard is exactly the type of evidence that the law says that you can and that you should and you must consider in deciding the sentence. You're going to be told that you can consider any aspect of the defendant's character or record in doing that. You're going to be able to consider his background. And we're going to talk about, Ms. Dees talked about it, and we're going to talk about it again a little bit. But there are things about this, about his life, about his character, that are mitigating, and that should be considered by you in deciding which of these two harsh and permanent punishments should be imposed in the case. You know, as you're going to go through, Judge Ridgway is going to instruct you on all the mitigating circumstances in this case. And there are, I believe, 37 or 38 that you can be hearing. about. I want you to listen to it, and you are the ones who decide the evidence and the witnesses and what you should believe happened in that. And sometimes you're going to have to decide between contradictions in the evidence, and we talked about this in the guilt-innocence phase. That's your most important job as a jury. But listen to the instructions that Judge Ridgway hears, and you're going to hear this about some, actually most of the mitigating circumstances. You're going to hear this language. All of the evidence tends to show. And then talk about a specific mitigating circumstance. Accordingly, in this circumstance, if one or more of you find the facts to be as all the evidence tends to show, you will find that the circumstance has been established, and then you decide whether it has mitigating value. In other words, for most of the circumstances you're going to hear, they are not contradicted by evidence, by witnesses, by anybody. What you heard was uncontradicted. What you heard was true about the backgrounds and things about it. What you heard, there can be disputes about little things, but the heart of what we're saying in this mitigation is uncontradicted because it happened. And it's about doing it. Let's talk a little bit more about this when we talk about mitigation, and keep in mind this other aspect about it.
Mr. Brown, could you keep your voice up so the court reporter could hear you, sir?
I'm sorry. Mitigating circumstances are individual choices. You'll have as a chance as a group to discuss with each of you what you believe the circumstance, what you believe we've proven the fact, and what do you bring, and what do you believe we've shown that it is mitigating. What do you believe in your head and your heart that it's mitigating? But then when the choice comes down to whether this is a mitigating circumstance that you should consider in this case, that is an individual choice. Each of you decide for yourselves whether or not this is a mitigating circumstance, whether this is a reason that should be considered to spare the life of Travion Smith and instead sentence him to life imprisonment without parole. And each of you decide for yourself whether to consider that mitigating circumstance. So discuss it as a group, but keep that individual choice in the mind when you decide whether or not it exists. You're going to get a list, as we say, of a bunch of mitigating circumstances, but there's one that you need to consider as well. At the very end, the last one you'll be instructed on. You can consider any other circumstance or circumstances arising from the evidence which you deem to have mitigating value. It's kind of called, we call it catch-all mitigating circumstance. That means is that as lawyers and judges, we don't necessarily get everything that's important in this case and put it on that sheet. There may be things about this case. There may be things about Travion's life. There may be things about the people in this case that you find to be mitigating that is not on that sheet. There may be things on there that you say, that is a reason I want to consider, that I want to hold to be a reason why somebody should be, why being punished, should not be sentenced to die. And when you find those reasons, and if it moves one or more of you, the specific reasons, then the answer to that mitigating circumstance is yes. And that should be a circumstance that you consider, not only in answering issue 2, but in deciding the fate of Travion in this case. Once you decide what mitigating circumstances exist, the next question is the weighing question, the one about whether which weighs more, the mitigating circumstances or the aggravating circumstances. The question is, and I think Mr. Waller and I agree that it's kind of got this confusing language, but the question is, has the state, basically comes down to, has the state proven beyond a reasonable doubt that the aggravating circumstances outweigh the mitigating circumstances? And in doing that, you take into consideration, you did discuss it as a group, but you take into consideration each of the mitigating circumstances that you individually found. And you give the weight to that individual mitigating circumstances that you felt have been shown, and you felt have value, and you weigh it in making a determination. If, and only if, the state has proven beyond a reasonable doubt and unanimously that the aggravating circumstances outweigh the mitigating circumstances, would you answer that question, yes? And then the process would continue. But when you look at the mitigating circumstances, and if you're not convinced beyond a reasonable doubt, if you are not unanimous, then it's your duty and your right to answer that question, no. And Travion Smith will be punished. Punished harshly, punished severely, and be punished with life imprisonment without parole. As we said, if and only if you answer that third question, yes, you would move down, you would then look at question number 4. And that has to do with whether the aggravating circumstances are sufficiently substantial to call for the imposition of the death penalty. When considered in light of the mitigating circumstances, when considered in light of the mitigating circumstances that each of you found individually, that each of you believe have some bearing in this case. And when you go ahead and you look at that question, you again have to, before you can answer that question, yes, you all have to be convinced unanimously and beyond a reasonable doubt that the state has proven that case, that the only answer, that the death penalty is the only appropriate punishment. They have to prove that beyond a reasonable doubt. But if you're not, if it's not been proven, if you are not unanimous, if you look at it and consider still the mitigating circumstances and everything and don't believe that the death penalty is the appropriate punishment, that Travion Smith should be punished and punished harshly and severely, but you as an individual or as a group believe that the death penalty is not the appropriate punishment, then the answer to that question is no. And then, if you say no, Judge Ridgway will impose sentence. And Travion Smith will be punished harshly, will be punished severely, but he will be punished appropriately with life imprisonment without parole. In our state and in our country, the death penalty is not appropriate for every case of first-degree murder. It is reserved for the worst of the worst. And when we talk about the worst of the worst, we don't mean just simply the worst of the worst crimes. We are talking about the worst of the worst people. And that's just not Travion. The worst of the worst are those who have killed before, those whose history and everything else shows that if they are not given the ultimate punishment, that they will kill again. Those who have shown no signs of having any redeeming value, or that redemption is not even a possibility. And that is not Travion. The fact is, Travion is not even the worst of the worst when it comes to this tragic and heartbreaking crime. During the first phase of this trial, during closing arguments, Mr. Waller got up and said, Ronald Anthony is a murderer, but so is Travion Smith. And he had an excellent point that he was making about the guilt-innocence phase. Ronald Anthony's actions did not excuse Travion Smith, did not justify what happened. And by your verdict of first-degree murder, you did say that Travion Smith was a murderer. But at sentencing, it is appropriate to compare the roles of the people involved in the case.
Objection.
Overrule.
And it's appropriate to compare the roles and to decide what is the appropriate punishment for Travion Smith. There is nothing that they have shown about Travion Smith's role in this case that is so much worse than Ronald Anthony's role, that Travion Smith should get the death penalty instead of another punishment, another harsh punishment, life imprisonment without parole.
Objection from
Sustained.
Motion to strike.
Jury's to disregard the last statement.
There's nothing that you've heard from the witnesses in the case. There's nothing that would suggest that Travion was the most culpable, that Travion was the leader, that Travion was the worst one in this case. What you heard was Ronald Anthony was the older one, that Ronald Anthony was the leader when they were breaking into cars, that Ronald Anthony was the one who arranged for them to get the ride out of North Hills once the murder was complete, and that Ronald Anthony was the one who arranged for the stolen items to be sold. Ronald Anthony's role in this case does not excuse Travion and does not prevent him from getting a harsh and serious punishment
Objection.
like life imprisonment.
Sustain.
In deciding Travion's punishment, you should compare their roles, both of their roles in this case.
Objection.
Overrule.
There's no reason to believe that Travion's role is so much worse than Ronald Anthony's, that the death penalty is the only appropriate punishment in this case. And you can consider, in deciding this punishment, Travion's upbringing, what happened, his background, how he grew up, and his mental health history. As we talked about, the law says you can consider all of that in deciding his sentence. But beyond the law, our own common sense, our own experience says that what happens in a person's life when they grow up, what happens in their family, it matters. You know, during jury selection, I'm sure you all felt that both sides asked you every possible question that could possibly be asked. There's one question that used to be asked that was in jury selection that we did not ask you. And that's, who would you say is the most influential person in your life? And that's because I think we all know that the answer for almost everybody would be a parent or guardian. As a group of people, we all have different life experiences. But one thing that I think that most of us are fortunate to have is a father or a mother or a guardian who loved us, who protected us, who helped guide us into becoming who we want to become. But look at who had the role of doing that with Travion and shaping who he was. You saw his mother, you heard testimony about what that was like growing up. You've read the DSS reports. She was using drugs. She was putting alcohol in her baby's bottle. And no, not every parent does that. And she completely neglected him. Now, as you've heard from from Travion's half-brothers, Corey and Aaron, And they are doing remarkably well now. And the question has been raised, if they could succeed, why could not Travion? Well, both of them deserve credit for their own success, and it's incredibly admirable how much they have achieved and everything else. But both of them, it's important to remember, went from that situation living with their mom to getting stable and loving homes afterwards that gave them the way to overcome that. But Travion had no such luck. First he went from his mother to a neighbor, Laura Cannon. But we know, from what we know about her situation, it was just as dysfunctional. In fact, she ended up being murdered by her husband shortly after Travion left. Some signs about the dysfunction that was going on there. From there, he went to stay with his father, Michael Clark. Michael Clark was not the one to provide him with the love, the guidance, with the protection that we all need. He is the man who physically, when he found out that Travion's mother, Antoinette, was pregnant with Travion, beat her and punched her in the stomach. He is the person who physically, mentally, and emotionally abused Travion. And when Travion was on trial for his life, his father refused to testify.
Objection.
Sustained.
It is in evidence. Mr. Love testified to that.
Sustained.
Sustained. And he cussed out his daughter when she said that she was going to testify about what went on in that family. But you know what may be one of the saddest things is, despite all those problems with Michael Clark, he was the only one that Travion had. Isn't he dumb? His mother wasn't there. Witnesses testified they barely ever saw his stepmother. Yes, Michael Clark may have seemed disengaged and it seemed that he often sabotaged the efforts to help Travion. He was the only family member, though, who was there. These providers and caretakers, these teachers and providers had virtually no contact with his stepmother, and no contact with anybody else. Michael Clark did not provide Travion with the type of love, support, and guidance any child needs, but nobody else did either. We have heard that Travion had serious mental health problems and that he did not get the type of long-term treatment that both Dr. John Blackshear and Dr. Anne Marie Evans believed he needed. Sometimes he didn't get the treatment because, quite frankly, his family did not have the money that was needed to be done. And that is unfortunate in itself. But occasionally, he did get into a program where they did have funds and where he began to show signs that he would succeed. People began to see improvement in Travion. They began to see the good in Travion. And when that happened, his father, for whatever reason, would inevitably withdraw him from the program and, in fact, sabotage any hope he had for success. Ms. V earlier talked about the fact that his father kicked his son out of his home and exposed him to prison back in 2013. Of course, Michael Clark had the right to do that. Travion did not, the law did not require Travion at that point, being 20 years old, that he didn't have to keep him in his house. But why, what would it cause a father to take the step to kick his son out of the home so he would be exposed to going back to prison? I'm sure everyone has a limit, but what was the limit in this case? Travion wanted to bring his child to the house for the weekend, and Michael Clark wasn't convinced that it was really Travion's son. Travion wanted to care for his baby. That was not the Michael Clark way. Michael Clark would rather have his son go to prison for a parole violation than have to help feed and home his grandson. Last Friday, the state had its last opportunity to present its rebuttal evidence. It was the last time for to present evidence about why Travion should die as opposed to spend the rest of his life in prison. And they talked about, in this, Travion's record, the probation officer, and problems he had in jail. But with the state, and the state has shown definitely that Travion has problems and some difficulties. But what the state has not shown in this entire case, and did not show it Friday, is that Travion is beyond redemption. We heard that he had been in prison, and he was in prison for the crime of possession of a stolen motor vehicle. That's all you heard. That's his prior felony record. And as horrible as what happened in this case was, Travion is not someone who has a long history of great and serious violence, who has a long history of seriously hurting people, that the only way to control him is to put him to death. It's just not Travion. And they presented evidence that Travion misbehaved in jail. The state found in the 2.5 years that he'd been in jail 3 examples of misconduct. They included him refusing to go to his room and having to be maced about it, making smart and insulting comments to a guard, and getting into a heated argument with another inmate. A heated argument where no one was hurt. Now let's be clear about this. Travion was wrong all 3 times, and the jail was right for taking actions and punishing him for what he did. But we all understand that things happen in jail. And these 3 incidents in those 2.5 years do not show that he is so violent, so out of control that he cannot be controlled. None of those incidents show that the death penalty is necessary in this case. Nothing that you have heard shows that Travion is beyond redemption. What happened to Melissa Huggins-Jones was horrible, tragic, and heartbreaking. And I will agree with what was up there. It was completely senseless. And Travion will be punished for the rest of his life because of what happened. But his history before what happened does not show that he is incapable of redemption. His behavior in jail afterwards does not show that he is not capable of redemption. Travion's never going to be part of regular society again. But if his life is spared, redemption is still a possibility. The testimony that you heard Friday gave us just a little bit of a glimpse of what Travion's life is going to be like from now on. Jail or prison has to have strict rules. And when Travion violated those rules, the jail took appropriate actions. We began to see a little bit of exactly what life in prison is like. Remember, the lockdown there started because an inmate had improperly changed the channel of the TV. And Travion failed to return to his room when he was ordered to do so. And he was pepper sprayed because of that. He got into an argument with another inmate. It was a heated argument, and he was put in 24-hour lockdown because arguments like that cannot be tolerated in jail. And that's what jail, that's what prison is like. You lose all freedom. As it should be, God's tell you what to do, when to do it, and you have to obey. Every aspect of your life is controlled. It is the tension of living that in prison with the not ability to do anything. Every aspect of your life is in the hands of prison officials while you remain behind bars. Prison, for most of us, simply sounds unbearable. It would be unbearable to go through it if it was only a week. But if you were in prison, if someone was in prison for a week, he or she could bear it because they would know that at the end of the week, they would be getting out, that there would be a future, that there would be hope. If someone were in prison for a year, the fear, the tension, the loss of freedom would be unbearable. But he or she could make it through it because they know that at the end of the year, there's a light at the end of the tunnel. He or she will be getting out. If it were for 10 years, imagine that situation for 10 years. But it would be how unbearable, how hard it would be. But at least that person would know. At the end of the 10 years, as long and horrible as it be, there is a future, there is hope, there is one chance of getting out one day. So for Travion. For Travion, there will be no such hope. There will be no future to look forward to. He will wake up from prison the rest of his life knowing, I am in prison. I will always be in prison. And I am going to die in prison. For the last 3 weeks, we've heard a lot about the life of Travion Smith. We heard about the horrible events that happened in May of 2013. And last week, you heard a lot about what happened in those 20 years of Travion's life. And now, it is about the future of Travion. We know how that future, where that future is going to end. It is going to end in prison. Travion Smith is going to die in prison. Now you will decide how he will die and when he will die. Punish Travion harshly. Punish him severely. But punish him appropriately and with compassion. Sentence Travion to spend the rest of his life in prison. Thank you.
Thank you, Mr. Brown. All right, members of the jury, I'm going to go ahead and call a lunch recess for your benefit, and when you return, we will proceed with my instructions to you on the law for this phase, and you'll then be asked to deliberate. I'll ask you, unless one of you indicates otherwise, to return to the courtroom or return to the deliberation room at 2 o'clock. Either any of you have any plans over the lunch recess that would make that difficult for you? All right, if not, I'll ask you to return at 2 o'clock. All of the rules remain critically important. Don't talk about this case with anyone or allow anyone to talk about it in your presence. Don't form or express opinions about the outcome. No media or independent investigation. No communications with any parties, witnesses, or lawyers. Please leave your notepads in your chairs and again gather at 2 o'clock in the deliberation room. Everyone else, please remain seated. Outside the presence of the jury, are there matters anyone wishes to be heard on? I have one matter I need to bring to your attention. Anything for the state? All right. I was made aware during the state's argument that the Sheriff's Department had notified the District Attorney's Office of the possibility that a juror had been monitoring social media relating to the defendant's sister. And so I'd like to inquire into that, find out what that information is. For the purposes of this inquiry, I'm going to ask Ms. Love, who I see in the courtroom, if she would, I'm going to ask that she remain outside the courtroom in one of the conference rooms just outside so that we can get to the, so we can get a full understanding of the issues that might be involved in this matter. So, Ms. Love, thank you for waiting outside for us. Mr. Cummings, I see, is here from District Attorney's Office. Mr. Cummings, do you want to share with us the information that you have? And I understand that this was brought to your attention by a member of the Sheriff's Department, Officer Hart. So in any event, would you mind letting us know what information you have?
If I could, I would just ask Bill Hart to relate the information that he had that involves a person at a coffee shop down the street.
All right, very well. Perhaps, Mr. Hart, if you could sit here, if Mr. Wall, if you could move that television so Mr. Hart could sit there. Mr. Hart, I'm going to ask that you be put under oath for the purposes of this proceeding.
Place your left hand on the Bible and your right. You solemnly swear the testimony you give this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please take a seat.
Mr. Waller, could you remove the easel as well?
Yes, sir.
All right, Mr. Hart, if you could just convey the information that you have, sir.
Yes, sir, Judge. It was probably about 9:15 this morning. I went over to coffee shop at the Sheraton. I can't remember, it's Cafe something at the Sheraton Hotel. And I go there regularly. I don't know the name of the girl, but she waits on me occasionally, and then she knows I work at the sheriff's office. And she asked me if I work in the courthouse, and I told her no, I worked in the actual public safety center next to the courthouse. And she started telling me about a friend of hers who, from what I gathered, was a juror in the case. I don't know that to be true, but that's the impression I got, was concerned about coming in today because of some contact that she had had on social media or some things she had seen on social media. And the gist of what I understood was that she may have seen some things that the defendant's sister had put on social media and had either commented on those or made some comment to someone about that, and that then the defendant's sister had put some things on social media about this juror, and that she was somewhat concerned about that and having to come into court today. And that was the term she used, social media. I don't know what type of social media it was, and I didn't ask a lot of questions. But as soon as I had gotten my cup of coffee, I went over to my office, and first thing I did was call the DA, Lauren Freeman, on my cell phone.
All right, and was there any description given of the juror that you believed was involved? Was it young, old, male, female, any description at all?
The girl at the coffee shop, I would say, is probably in her early 20s. She's a part-time student at NC State, and she was talking about this being a friend of hers. So I was under the impression that it might be a younger person, but I really can't say.
All right. And you've not had the ability to go into any of these social media sites and examine any comments that might have been posted? Have you?
No, sir.
You've not had the
No.
opportunity to do that or the ability to do that?
And I didn't do anything to go back and talk to this girl, or the only thing I've done is talk to Lauren and then talk to the deputy that you had call me.
Yes, sir. Thank you. All right. Any follow-up questions that council, for Mr. Hart? I'll talk with you about perhaps what the next steps ought to be, but anybody feel that there's further information that we need from Mr. Hart?
I mean, Your Honor, I don't know that Mr. Hart has an answer. He said that his vague impression is that it's a young person. I guess the only other question would be, does he have a vague impression whether they're male or female? But
I asked that, but I don't think you're just speculating that it's a young person because it's a friend of the young person with whom you were interacting.
Again, I didn't ask a lot of questions, and I tried to think back to see if she used the term she, but I can't be certain that she did.
All right. And Ms. Shakita, and you say she works at the coffee shop down at the Sheraton, is that correct? All right.
And they only go till 11:30 each morning, and she will also be working there tomorrow morning, but she works in the evening some at the Sheraton, I know, but that's all I know about her.
All right, very good, thank you. Ms. Shakita.
I was going to tell Your Honor, after getting this information and speaking with Ms. McGovern, I think that she can shed some light on the concern.
All right.
And so I'm sure she's glad to come back up there if Your Honor would like for her to do so.
All right, yes. Ms. McGovern, do you have further information about this matter that you could share? If you want to, thank you, Mr. Hart. If you want to
Yes,
step
sir.
down, sir. Ms. McGovern, if you want to step around here. And let me have you placed under oath for the purposes of this inquiry as well.
Yes, sir. I found about the direction. You solemnly swear the testimony you give this court shall be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, ma'am.
All right, Ms. McGovern,
Yes.
what information do you have that you could share with the court about this incident?
I also work at the Sheraton. I was there this morning and I got a coffee from my friend. I don't want to say her name. I believe she's talking about me, and obviously I'm not a juror. And over time throughout this trial, we have talked about this. I've only talked to her about information that has been open to the public, what has gone in the trial room. I've not talked about anything confidential. And she also has been following along with the case.
Okay, so this is someone, and did you speak with this friend of yours this morning?
I did. I got actually a coffee from her from Cafe Sienna is in the
All right,
Sheraton
Cafe
Hotel.
Sienna is the name of the coffee bar. And generally, did you have conversations this morning about the case?
Yes, we did. Said I was going to court this morning. And what happened on Friday with the Miss Love and the Twitter, she had just said, "Are you scared of seeing her today?" And I said, "No."
I see. All right. Well, that certainly is an explanation of what may have occurred. All right. So based on that, Ms. Shakita, are there any follow-up questions that you would suggest for Ms. McGovern?
At some point, this girl that you know from the coffee shop Did y'all have a conversation about a different type of social media other than the Twitter information?
Yes,
And can you tell the judge about that?
Snapchat. I know another coworker who knows Miss Love. They had worked together previously, and she also knows that I'm an intern here and that I am on this case. And she has her on Snapchat that had said, "Can't wait to be on Monday. Can't wait to be in court on Monday," and other. Yeah.
All right, so that would be, okay, let me make sure I understand the connection here. This is another coworker of yours at the Sheraton
Yes.
who follows Miss Love on Snapchat.
Yes, I think she said after she had seen that, she had taken her Snapchat down. But
And-
she was, I'm sorry, she was confused like why she was saying that stuff. And then when she had found out the next day I was testifying against that, she said it all made sense now.
All right, all right. So this is just simply information that Miss Love was posting on a different social media platform that you don't have access or the ability to follow because you're not
A
a friend
Yes.
on that platform, but your a third coworker or another coworker does and said that there was a comment.
Yes.
on-
They had
about
worked
that.
together previously.
All right, all right. Okay. Any further questions that you would,
Just to be clear, Ms. McGovern, have you ever talked about this case in front of any of the jurors?
No.
Ms. Brown, Ms. D, do you have any further inquiry? Yes. All right. Okay, thank you, ma'am. There certainly, as many times as I've warned the jury about communicating in any way whatsoever with any parties of witnesses, I would certainly surprise me if a juror did not understand the gravity of that sort of communication. So this certainly is an explanation that seems plausible. There are a couple things we could do. One, we could inquire with Ms. Love about whether she has had any communication with anyone that she believes to be a juror in this case, or I'm not sure. Since she is simply posting things, I'm not sure that she would know whether anyone who's on the juror has viewed that, or so that certainly would be one area of inquiry, and I'll say that Ms. Love certainly has the right to discuss this case if she chooses, so long as it's not in violation of any of these court orders, which certainly communicating with the jury would be. The other thing that could be done is we could track down this individual who shared this information with Mr. Hart, inquire with that person as well. It sounds like we at least may have a name, may be able to track that person down this afternoon. If not, I could do it tomorrow morning when she reports for work. I'll hear from counsel as to your views on how best to proceed under these circumstances. Yes.
Investigator Jerry Winstead has tracked her down and spoken with her, if you would like to hear from
That would be helpful.
Thank you.
Yes, sir. And you can be sworn as well. And
Do you solemnly swear the testimony you give this court shall be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you, sir.
Investigator Winstead, if you would tell us what information you have.
After speaking with DA Lauren Freeman this morning about this, I went down to this coffee shop at the Sheraton and inquired about it with the young lady working at the counter. I did identify her name, and I can identify her to the court if you wish. And the urgency to get down there to talk with her was she was getting ready to get off shortly this morning. So I actually talked with her a little bit before 10 o'clock this morning, And everything that that young lady just told the court was pretty much the same thing she told me.
Ms. McGovern just explained to the court.
Yes, sir. Yes, sir. Pretty much the same thing. And the young lady basically said that she had not had any communication with any juror, didn't know any juror, that the only person she knew related, anywhere closely related to this case was the young lady, Grace. And that they had just general conversations about it, nothing specific at all. And that was pretty much all that she told me about her involvement in the case. And she did say that she had been talking to Mr. Hart some throughout the week, and this morning in particular.
All right, thank you. Any follow-up questions for, and Mr. Brown, Ms. D? All right, thank you, sir.
Yes, sir.
All right, well, based on this information, I think that is really no evidence that that there has been an improper communication with jurors or monitoring of any social media sites by a juror. I think there was an initial misunderstanding that has been cleared up, I think, to the satisfaction of the court. I'm inclined to simply leave this issue as it is and not take any further action. Ms. Shakita, Mr. Waller, do you wish to be heard on that? Mr. Brown, Ms. D?
No, sir.
All right, that's what we'll do. If you will thank Ms. Love for remaining outside available, but I don't see the point in even discussing it further with her, so.
Other than maybe, just someone to show her that she's not in any trouble, given how scary it might be if you, under the circumstances and all. So that.
All right. All right. Ms. Love, thank you very much for waiting outside for us while we dealt with this matter. We appreciate it. There's no further need to inquire of you, ma'am. All right. With all of that being said, if there's nothing else, then we'll simply be in recess until 2 o'clock. And I have printed out copies of the instructions. The only change I've made is, do you have a copy? You do not have copies of those, but I had referenced in the elements of a robbery, the Victoria's Secret jewelry box. I have taken that reference out and left it simply as taking and carrying away items. I did not specify any particular items with respect to that. That's the only substantive change I made in the instructions. All right, with all that being said, then we'll be in recess until 2 o'clock. Yes?
What did you decide about the expert witness?
I've included the expert witness, yes. In fact, I'll give you printed copies of those. Instructions now. And you're free to review them, but I did include the pattern instruction on expert witnesses that was given previously and just simply included that as well. All right, very good. Thank you. We'll be in recess till 2 o'clock.